Everybody's in? Good afternoon, everybody, or good morning, as it were. In California, it's 9 a.m., a couple minutes after 9, a couple minutes after noon here in New York, where Brother Brian and I are working today because we were subject to Tropical Depression Ida, which flooded most of northern Jersey and New York, including the offices of FFLGuard, where there is no hot water. So Brother Brian is here at my house where we do have hot water, and we are operating from here today. It is the day after Labor Day, September 7, 2021. Happy Rosh Hashanah to those of you that celebrate that holiday. If you were not on our call earlier, we did have our nationwide call at 11 a.m. Eastern, 8 a.m. Pacific. There will be another one on October 4th, same bat time, same bat station, with, of course, a California call to follow. Don't know, as far as a FFLGuard proper perspective is concerned, how many help desk questions we had come in from California, nor do I know how many ATF inspections opened in California, but the people that do know that are on the phone, and that would be Avis and Brian. Avis, what does California look like over the past month? I know that as a whole, over the scope of the country, there have been a ton of inspections that have opened. But what's going on in California as far as...
We've only had one in California, but that doesn't mean that they're not going to come out this week, next week, whenever, especially if your office is close to one of the ATF's offices itself. When they're short on money, they inspect close to the office. I will tell you that I can vouch for that in the past. But yes, we are seeing a lot of inspections. So if you have time, do an inventory. A lot of people are not doing their inventories on a regular basis. We are having people, oh yeah, I think my books are off, but surely they'll forgive this one error. Don't count on it. We know for a fact that they're out there looking for things that we need to be on, watch our P's and Q's. So please do your inventory. Try to do one every 6 months, at the very least every year. We don't encourage you to do it every day, but hey, if you have the option, you can do it.
We do encourage them to do it every quarter, though.
Yes, every quarter would be wonderful.
Ideal, yes, yes. And we did have that inspection in Dublin open and close recently.
Yes.
But other than that, I can't think of any other ATF inspections. Now, I can't speak to the California DOJ. You know, they're an animal unto themselves. But yeah. I will tell people that if they get inspected, you please need to contact us. You please need to call in. Because there are things going on with regards to how violations are being classified. And if they fall into a classification that's subject to immediate revocation pursuant to the Biden and administration's zero tolerance policy, then you will be sideways for sure without our assistance. And the best place to address an improper classification of a violation is right there when you are doing your closing conference with ATF. So before you sign that report of violations that they ask you to sign after an inspection, that's the best place for us to address it. And I'm happy to do that for you. On the line with us from California, I believe, let me look through my little, we've got, I see Josh and Matt coming to us from California. I also see Hanky Panky Poo coming from Kentucky, our business guru. Before I jump to the California dudes, Hank, you want to regurgitate a little bit of what you said earlier on the national call, and maybe, I don't know if you have any California insight, but the floor is yours.
Yeah, I don't have anything specific, to California. I haven't been out there recently, but I just made over the last month a pretty wide trip around the eastern part of the U.S. visiting retailers for various reasons. And, the gun situation, asked everyone across the table, where's your anxiety around being able to get the firearms that you need to sell and that anxiety really wasn't there. They were all very comfortable and very confident with their ability to get the firearms that they wanted in the quantities that they wanted. On the ammo front, still a mixed bag. It seems like some people are being fed, some people aren't. But the big thing I did notice is from a firearms and ammunition perspective, a huge spectrum of pricing. Some folks have got pricing from 9 months ago still on their products, and other folks have adjusted and have more market sort of on point market pricing on things. And so I just recommend everyone really check your pricing, making sure you're on market with product, because I saw very consistently those that had older, higher priced, high demand, low supply pricing had plenty, like more product than I would expect on the shelf, and those that were more market realistic had product but lower inventory levels. So they were at that good balance point of sell through and not too much stagnant inventory from that perspective. So, again, I encourage everyone, go look at the marquee items, look at the things that you're selling in your store, make sure you're on point with the market volume. On the ammunition front, I can't speak specific to California, but I'll speak to a more nationwide perspective. There's a lot of market indicators from street level data that I've had some looks at, and we're probably a couple months away, should nothing change in the market space in the sense of civil unrest or anything like that. But when it comes purely from a manufacturing and demand cycle, we're probably within 60 days of seeing a supply of ammunition meeting, or in some cases, depending on caliber and where you are in the country, exceeding the demand of that product. So that means prices are going to drop further than they are now. And as I've mentioned in previous calls, there may even be some significant bloodletting for those that have above market priced ammunition that they purchased that are in off brands, or import brands and things along those lines. So be ready for a potential rocky road here in the next couple of months when it comes to ammunition market pricing and customers becoming more price sensitive when it comes to their purchases, because it's definitely on the horizon.
Thank you, sir. Appreciate that input. And now we will turn over to our Californians, like on Saturday Night Live, the Californians, Josh Dale and Matt Cubiero. Should we go with age before beauty? I think that would be Mr. Dale.
That'd be Lee Smith in that case.
Thanks, Matt.
Hey, Lee's here. Hey, Lee, how you doing? All right. Yeah, I'm happy to go first, and I wanted to talk to the folks today about something they may have read about over about the last week, which was a judge held that Prop 22, which was the Uber Lyft independent contractor statute. It was passed via initiative. It allowed for Uber and Lyft drivers to remain independent contractors. You may have read about that order from the court, and you may have questions about how it affects you guys as firearms retailers. I've gotten a couple questions from a couple of people about how it affects things such as use of NRA certified trainers and other folks within their businesses. So let me give a brief overview. As most of you who are retailers in California know, in 2019, there was this fairly draconian law called AB 5 that was passed that basically very, very significantly narrowed the scope of who would be considered an independent contractor and who should be treated instead as an employee. And so there were a lot of folks who were operating out there, happily operating out there as independent contractors, who now suddenly were going to be employees. And there were some shifting of some jobs from California to other states as a result of this. One notable industry was in the freelance writing and freelance artist industries, because those folks under this new AB 5 were going to be required to be treated as employees, and the companies that were hiring them didn't want to do that, so they just started hiring independent contractors from other states. There were some amendments in response to the outcry over the restrictiveness of AB5. And as a result, the rules were loosened up a little bit. And then there was this SB 22, which was the very heavily lobbied for by Uber and Lyft, because it would allow them to keep their drivers essentially as independent contractors rather than being classified as employees, as they would be under both AB5 and its amendments. And I won't get too much into the politics of that, but SB 22 passed by a fairly decent margin. And then what happened was it got challenged by a local union, and it got challenged on a very sort of arcane legal issue having to do with how the law could be amended. So it didn't really have to do with the substance of the law. It had to do with restrictions that were in the initiative as to how the legislature could make amendments affecting the law. And a court found that that language, nothing again to do with how the workers were characterized, but rather this language having to do with how the law could be amended in the future was something that ran afoul of the California Constitution. So the question we've gotten, like I said, is what's the effect of this recent court order on AB 22 with regard to me as a firearms retailer? And the answer is it shouldn't have any effect, because it didn't have any effect when it went into place. So remember, under AB 5, there was this 3-part test that was adopted as to when you could consider somebody an employee versus an independent contractor. And in order for them to be a bona fide independent contractor, they had to be free from your control and direction. That was one part of the test. Another part was that independent contractor had to be customarily engaged in an independently established business that was in the same industry as yours. Those 2 tests are somewhat easy, and they mirror what the old test was in some aspects. The third part of the new test is the killer for most people who were independent contractors, and that is, does the worker perform work outside the usual course of the hiring entity's business? And this is where most people who were being used as independent contractors, this is the part of the test they fail, because in a lot of instances, and I'll give you an example, the legal profession. The legal profession uses independent contractor attorneys. Sometimes you'll see them on letterhead. They're called of counsel. Again, if you're a law firm and you're using independent contractors who are also attorneys and they're performing legal services, that's within the employer's business. And so, but for an exception in AB 5 that allowed attorneys and doctors and some others to continue to be treated as independent contractors under this AB 5 test, anybody who's doing anything that the employees or the employer's business is doing is supposed to be classified as an employee, not as an employer. And as firearms retailers, you know about the whole rigmarole that comes with having an employee versus having an independent contractor. So where this affected you when AB 5 was passed, and why it still affects you regardless of the status of Prop 22, is that you as a firearms retailer, if you're holding yourselves out, for example, as providing firearm safety instructions, let's say your FFL is called the Dublin Firearms Safety Coalition, or the Dublin Firearms Sales and Instruction, you're going to likely be held to be conducting the same business as, let's say, an independent contractor you may bring in to teach firearm safety classes. And so that's where the issue becomes of a particular concern to you, because you have to worry, okay, well, wait a second, at some point, are the EDD or the Department of Industrial Relations going to come in and try to claim that I've had a bunch of off books independent contractors and I owe a bunch of penalties as a result of having quote unquote misclassified these safety instructors? That is something that you should be concerned about. Let me tell you sort of what the test is when you're dealing with independent contractors. And really the 2 that I think would potentially be the most applicable to firearms retailers are going to be either use of sort of having a symbiotic relationship with a firearm safety instructor and, advertising that person's services. And like I said, if you hold yourself out as like a one-stop firearm shop, you do firearm safety. If you have a range and you do firearm safety and you sell firearms. So if you're one of those FFLs that's a range and you also offer those services, that's where you have to really worry about this classification issue if you're using outside folks to come in and teach some of your customers. The other area that I think it's going to potentially affect firearms retailers is if you are selling reloads, and it's going to be much more of a narrower concern, and it's going to be if you have ever employed anybody to sell branded reloads for your particular FFL. So let's say you have the Dublin Firearm Safety Center reloads that you sell, and you sell them for $20 for 50 rounds of 9 in a bag, and you have this branded stuff, but you're bringing somebody in who's an independent contractor to do the reloads. And I'll talk about the circumstances where that person could potentially be deemed to be your employee under these very restrictive California laws. So like I said, there was AB 5, very narrow, hue and cry over it. Then there were some amendments that loosened it up a little bit, but not a lot. But for purposes of you as a retailer trying to figure out, well, can I bring in a safety instructor or a reloader? Let me explain to you the exemption that potentially applies. And that would be this business to business exemption that was written into the amendment AB 2257 to the original restrictive law. And basically what it is, it's a business to business exemption from having to classify somebody as an employee. And what this exemption basically says is if you're dealing with somebody else who is a sole proprietor or is a partnership, limited liability company, or has a corporation, and they meet certain tests, you can treat them as a bona fide independent contractor. One of those tests, just so you're aware, is you have to have a written contract with them, and that written contract has to specify what they're getting paid. The second thing is you have to make sure that if there are business licenses required in your jurisdiction, that the person you're contracting with has their own business license. If you have to make sure that if you're dealing with an outside person, they have a separate business location, even if it's their house. In other words, for you as an FFL, if you're dealing with a safety instructor, you're going to want to make sure they've got a business license, and that business license lists a business address other than your location. And that's going to be important. And then finally, you're going to want to make sure they perform the service for businesses other than your business. So if you have a captive instructor or a captive reloader, these are big red flags that if either they or some regulatory agency came in and scrutinized that relationship, there's a strong possibility that they're going to be deemed to have been misclassified and that you should have been treating them as an employee. And unfortunately, that's one of the realities now when you're dealing with a state that has a supermajority of one party, and you get policies like this. But in any event, you need to be mindful of that. And like I said, the two big areas where you need to be the most mindful, obviously, are with firearm safety instructors and with reloaders. If you're treating anybody else as an independent contractor, like your floor staff or your warehouse workers, you're in big trouble there. So I'm going to assume that everybody knows and is classifying those workers correctly. Those should all be employees, obviously. Now, the second topic I want to talk about, we've talked a lot about mask rules for both employees and for customers, and obviously it's been sort of this changing thing that we've been dealing with throughout the past almost now 18, 19 months of dealing with the COVID pandemic. We've talked recently about how after June 15th, the rules changed and kind of eased up for you in dealing with employees. But some of you guys may be going around, you go to the local mall, you go to a strip mall, and some of the stores say, well, everybody in here has to wear a mask, and other stores say no. And that may lead to you questioning, well, what's the exact rule? Well, the exact rule is that you guys are still covered by the June 15th OSHA regs with regard to how you treat your employees, which means that non-vaccinated employees don't have to wear masks. They can wear masks if they want. I'm sorry, I said that wrong. Vaccinated employees do not have to wear masks. They can wear masks if they want, and you have to provide them if they want them. Non-vaccinated employees must wear masks. If you have outbreaks, then everybody has to wear masks. And you still have to have your OSHA plan in place. These rules are different where there are local mandates that potentially conflict with the OSHA regulations. And we talked about in one of our previous sessions about how, like, the LA County health order that came out shortly after the June 15th order in response to the Delta variant gaining prominence, it's requiring everybody indoors to wear masks. And we talked about sort of the conflict between, well, here you have a state regulation that says no mask, but you have a local regulation, and where the safe way to go with that is. But whether you're in one of those jurisdictions or not, you may decide for whatever reason, well, I want everybody to wear masks. And the question is, can you do that? When you walk into a mall and you see one business going, if you want to come in this store, you must wear a mask. And you see other businesses going, no, you know, we're following a less restrictive rule. Do you have the option as a retailer to do that? And the answer is yes, you do. But when you do so, you lose some of the protections that you had from failure to accommodate claims. You guys may recall that when this whole thing started and we had these very sort of restrictive lockdowns where, you know, in some instances, some businesses were completely shut down. You know, we dealt with that issue here at Michele Associates with regard to local jurisdictions that were just completely shutting down FFLs, and, you know, we were filing lawsuits to deal with that. But then when the FFLs were open, they had these requirements that only so many people in the store and everybody had to wear masks. And some of you folks may have encountered people who were going, well, I have a disability and here's my disability card and you better let me in. I had several lovely encounters of this of this sort, where, you know, I had long conversations with aggrieved customers about how we were, or my clients were violating their rights, and we were violating the ADA, and, you know, had a nice measured conversation trying to explain to them that no, there were these local health mandates and this is how the ADA works, et cetera, et cetera. Well, we're not at that point right now, thank goodness. But the question becomes, if you as a business at this point go, well, I just want to be extra careful. And, you know, I don't want to judge you either way. But if you said, I want to be extra careful and make everybody coming into my store wear a mask, what would happen to you? And the answer would be, unless you have some program in place to allow reasonable accommodations for people who have a disability that doesn't allow them to wear a mask, you're potentially subjecting yourselves to liability under the ADA and under what's called California's Title 24 in the Unruh Act. And so what happens, and I've seen this, you know, I was at the mall this weekend. My kid wanted to go to the mall. And if any of you know me, you know, me and malls go together like cats and dogs. I think Amazon was the greatest thing ever invented. But nonetheless, my kid wanted to go to the mall. So I took him to the mall. And I see a lot of these signs on, not on all the stores, but some of the stores in the mall. And they say, you can't enter without a mask. But there's no discussion in there at all of we will accommodate people who have disabilities that don't allow them to wear masks. So if you're going to implement everybody in the store must wear a mask rule, you better make sure you also have posted that you will accommodate people, and you better have a plan in place for how you're going to identify people who legitimately need an accommodation versus maybe some of the folks who are going around with the I have an ADA card is more of a political statement. And then and train your employees on how to deal with those situations where they're confronted with and may not understand and have to assess at that point whether a customer has a legitimate disability that requires a mask accommodation, how to ask appropriate questions in order to figure that out, and then what sort of accommodation will be provided for those people. And again, remember before when there was a giant state mandate about everybody in stores had to wear masks, you could always fall back and say, well, it's a reasonable accommodation for me to say you can't come in my store at all if you're not wearing a mask, because that's what the state health order says. You can't say that anymore. You can say that in certain localities like LA County, but for the rest of the state where, again, it's if you're vaccinated, you don't have to wear a mask, you're no longer protected by that particular justification. So you have to come up with an accommodation plan that is more than just if you don't wear a mask, you're out of here, and we'll give you a personal shopper, or you can go online. So if you have a question about potentially implementing a everybody must wear masks rule, please feel free to contact us through the FFLGuard help desk, and we can try to walk you through that. But it's it's something that you have to be very careful with, just like you've had to be careful with your OSHA COVID plans, and you've had to be careful with your COVID leaves and all that stuff. This is another area that's potentially fraught with a lot of traps. And so again, if you decide you want to do that, and I don't know that there's anybody on this particular call that will, but if you do, please feel free to contact us, because that's something that could get you into a lot of trouble if you do it wrong. Well, it's a lovely day here. I think we're going to be 83 degrees here today. So I am done. I'm going to go out here and play as soon as we get done with this call.
Thank you for that, Josh. And a reminder that this is recorded, so we do get a lot more influx on recorded watches of our video than we do usually at the time of the taping. So we could get input from clients at any time on this, and we will certainly send them your way. That being said, last but not least, Maddie the C, our Californian. What do you got for us, Matt?
So it's since last time we spoke, it's at least from the California side of things, it's been fairly quiet. Nothing too significant has really occurred between now and our last meeting. I did want to point out to people, if they didn't already hear about it on the federal side earlier this morning, that we have a 24-hour period left or so to submit any comments regarding ATS proposed rule for stabilizing braces. So if you're interested in that, I'll post a link here in the chat here in just a second. So that comment period is supposed to end tomorrow. Now, that doesn't mean that the rule becomes final tomorrow. There's still a rulemaking process that ATF has to follow, which we'll wait and see what happens. And they basically have to look at the comments and consider the comments and then determine whether or not they want to make any changes to their proposed rule or anything like that. And so they should already be doing just that with the prior comment period that has already closed for their redefinition of a firearm frame or receiver. And so we're just waiting to see what happens with that as well. As far as the California side of things, specifically regulation wise, the California Department of Justice is going to, it looks like they're going to be finalizing the DROS fee regulation here relatively soon. We already got the emergency regulation for that, and that's already been in effect for dealers now since earlier this year. And so that really, from a how does it change your daily lives, so to speak, this doesn't really make any changes, just finalizes the emergency rule, which is currently in effect. From the legislative side of things, however, there are a couple pending bills that are going through some amendments, and I'll be looking at those here later this week, specifically SB 715, which talks about the rules generally governing the sale, transfer, and loaning of firearms to youths and minors, basically to use, so to speak, as I like to say. But that's something that that we have to look at first. And of course, it is just a proposed bill, so it's not something that is taking effect anytime soon. But there were some significant amendments made to that here last week. And so, of course, the governor has until, I want to say, October 10th to make any final decisions on whether or not to sign any of the bills that actually get passed out of the respective houses and go to his desk for signature. We will, of course, be monitoring that, and anything that, of course, does get passed and will be affecting firearm owners generally, we will be putting out more information on here in a bit. But nothing has been set in stone yet, and so it's just sort of waiting to see what happens at the legislature at that point. Besides that, still seeing issues with COEs, guys. If you guys are going through the process of you have renewals coming up for your certificate of eligibilities for either you or any of your employees, make sure you get those in as early as possible. The DOJ is, of course, notoriously slow still in getting those processed. And I've kind of seen some people having better luck than others. And so it can vary, but so it's kind of a crapshoot at the moment to determine how fast you actually get your applications processed. So the sooner the better in that sense. And that's pretty much it as far as the regulatory and legislative stuff that I have on my side. I think we have Lee here, Chris, if you wanted to pass it over to Lee, if he's got anything that he wants to add for ranges or otherwise.
Absolutely, Lee. We'd love to hear from you. And just a quick reminder, Chuck did call me and say to remind people that the Supreme Court case coming out of New York City, of all places, on permitting will be argued on November 4th, I believe. So he just thought that was of note for everyone to keep in mind. Lee, what do you got?
Sure. For those of you that don't know me, my name is Lee Smith. I work at Michele Associates, and I handle all the range matters up and down the state. And we have a significant amount of ranges that we represent. Right now, I'm just monitoring. Chuck has asked me to participate in these meetings to kind of get a feel for what it is that FFLGuard does in the process. As Chris and Brian know, we are contemplating a program that we will hopefully soon be implementing to cover ranges in various aspects. For instance, I think Josh alluded to it, that there are many ranges that have pro shops, so they maintain an FFL. So there's a lot of overlap there. But primarily as an environmental land use attorney, I am particularly interested in protecting ranges from NIMBYs. The attacks are significant. And it's not only NIMBYs, it's also antis in the bureaucracy as far as agencies, whether or not it's federal, state, or county level. And there has been a significant uptick in range inspections and notices of violation being issued. So they are really vulnerable these days. And my hope is that we can get this range shield program up and running very soon. And hopefully then we can add that to this platform, and I will have more information for you as far as how that is going.
Chris, you're muted.
Unmute.
There you go.
That's our California call. Thanks for everyone participating. We will see everyone again on October 4th. That's right, at 9 a.m. Pacific, noon Eastern. If you have any questions in the interim, please direct them to the help desk. Stay safe, and we will see you next month.